sent your notices, disgraced, sent his repeated, also disgraced, or dishonored, is a better way to put it. And then the history is given back to you. At this point, you and CD have the administrative process complete. So that would be the same thing that would happen between the ports, back and forth. Do I have my olive oil? No. Where is it? Well, it's this. Well, it's that. Well, it's this. Or just dishonoring it by being silent. And then you'd have the port authority or notary write up the information, give them the presentment, show them that the captain's log is good. The captain would also probably just keep him out of this problem, do the same thing and be happy to give you his logs and whatnot of what was on the ship. And of course, then that would go along with the notary presentment and your presentment as well if you had it in the beginning. And so at this point, that administrative process is done. The affidavit of AB, along with the certificate of notary, now becomes the basis for a court action against CD, which is exactly the same way it worked back then. Maritime Admiralty law and this administrative process has not changed for, I don't know, 5,000, 6,000, maybe even 8,000. I don't know. It goes way back into the BCs. I know it goes at least back to 4,000 BC. And it probably predates that by quite a bit because it's a very simple process to just make sure that people are in honor. So understand that if you do this process with anything regarding a corporation or anything else or anybody else, and they don't get back to you, you will easily win in court because it's all about honor and dishonor. All the facts are there. They owed the thing. Here's the contract. They never argued the contract. Done deal. And then if they still don't answer the lawsuit, you can just move for a default judgment. If they do answer the lawsuit, there really won't be anything they can do, and then it will be called a final judgment. And there's different kinds of judgment. You can look up the word judgment in Bouvier's Law Dictionary and see all the different kinds of judgments that there are. So I won't go over them ad nauseum right now. But anyway, so a default judgment would be where they don't answer. A final judgment would be after everything's done, the trial's over, and all the evidence has been presented, and the jury said, yeah, the guy owes you, right? Or if you just did a bench trial, the judge said, yeah, the guy owes you. And then you do a collection. Now, in going into collections, you can do various different things. Like you can do, let's say if it was somebody's house, you could do what's called a writ of assistance. They used to be called writs of execution. I think some states might still call them that. When you do a writ of execution, that's when you're going to execute the judgment. That's basically what it means. You're executing the judgment. And you go and forcefully take back you just keep taking stuff until you're made whole. If it's a kind of debt scenario where he owes you, but he won't pay, and say he absconded or took all his money out of his bank accounts, which, by the way, if you know that there's a lawsuit against you and you do that, that's a crime in itself. Which is funny because that's exactly what the judges in Colorado did with Drew. As soon as they found out that they had an arbitration award, one of the judges moved, I think it was like 5 or 6 houses out of his name and put them into his mother's name as soon as he got notice that that he'd lost in the binding arbitration through the dock set, meaning Drew did everything and had the dock set done and put him through binding arbitration regarding the KW and got the arbitration award. And then it's interesting in Colorado, it says that on the Public Records Office statutes that as soon as a judgment is filed into the county recorder's office, like land records, like you put it onto the land records, it's considered cured. So technically what Drew could do right now is technically file for foreclosure against that judge's house because he has the award and it's more than the house is worth. And so, the other thing is that it automatically becomes a lien on the house. So basically that judge can't sell his house at the moment. And if Drew's waiting on seeing if we can get a bill through the Colorado legislature to just pay it. The state kind of stepped in and tried to defend the judge in one of the federal confirmation hearings. Well, if the state steps in and tries to defend somebody, then the state's the one that has to pick up the bill. They've stuck themselves to the tar baby, and that's their own damn problem. There's nothing to do about it now. Or we can just go at it and foreclose on the lien that is now in full force and effect on the county recorder's office because the judgment got filed. So, but again, that's a real bad aspect of dishonoring the presentment. Not only did the judge not argue, it wasn't like an argument, they didn't say anything, but they stayed silent and they moved the assets. That is a big no-no. You cannot do that. Because basically it comes down to, I mean, literally we could turn around and sue him right now. We could file criminal charges, convene a common law 25-member grand jury, and try him for common law theft, which the punishment for that is death. So technically, at this point, we could go hang a judge, and all doing it through proper due process. All of it. We didn't tell that idiot to move his houses. We did tell him that there was an arbitration hearing, and the arbitration company told him there was an arbitration hearing, and he didn't decide to show up. So is that your problem? No. So that's how this procedure goes. And in finishing up the little story here, all notices were given. Okay. Now, we never did anything as far as notary presentments. You don't have to if you don't want to, but a notary presentment is definitely something that you can and should do. So that's something else that Drew could do. He could do a notary presentment, attach the lien with the arbitration award, and start a new process. And this would be a process regarding collection, and say, look, the lien's here. An arbitration award is a judgment. Put that in the law part, and give him so many days to start making payments. If he doesn't, go through this whole entire process, and then at the end, warn him that you will foreclose on the lien. It's really all you got to do, or really all Drew's got to do, I should say. To continue, okay, so that's process. That's your administrative process. Be an honor. So then in court, you can think of the court process as a formal series of presentments, right? Like this back and forth thing. Each time a presentment is made, i.e. a court paper is filed, the responding party has an opportunity to honor or dishonor the presentment. The response, whether honorable or dishonorable, in turn becomes a presentment. Your objective is to never dishonor the other party's presentments. If the other party persists in argument or silence, you can stay in honor by refusing his argument for cause, stating the cause, and giving him an opportunity to cure the defects. If he refuses to stop arguing, you stay in honor as he continues in dishonor. This is something that went on just recently regarding a debt case in Michigan. We did a plea and abatement. They dishonored the plea and abatement because they failed to answer the plea and abatement. And a plea and abatement is something that happens before anything else in a court case happens. So in this case, we were saying, look, we're filing a plea and abatement because we're not sure who the hell you're suing. Are you suing the man, meaning one of the people of Michigan, or are you suing his estate? And they wouldn't answer, because of course that would be blatantly obvious as to what they are doing. But the point is they didn't answer it, and they dishonored it. They didn't answer it. So now it's going into appeal because we're going to say, look, we were waiting for an answer. They didn't answer it, and they have to answer it. And throw it to the appellate court to say that common law process, an aspect of abatement, well, this is chancery too. Chancery process is a suspension of all proceedings in a suit from the want of proper parties capable of proceeding therein. It differs from an abatement at law, meaning common law, in this, that in the latter, the common law procedure, the action is in general entirely dead and cannot be revived. But in the former, the chancery part, the right to proceed is merely suspended and may be revived by a bill of reviver. But that means even after you do a plea and abatement and they don't answer it in practice, they have to do a bill of reviver to bring it back in, which most attorneys wouldn't even know what the hell that is or even know where to find it. So it would stay dead both ways. So that's kind of a little thing, plea and abatement. We can go over the plea and abatement later. So that's just an aspect of court of as far as dishonor of something that just happened recently, as far as dishonoring a presentment. And a plea and abatement is a presentment. So, okay, next part, parens patriae. Parens patriae originates from the English common law, wherein the king had royal prerogative to act as guardian to persons with legal disabilities, such as infants, idiots, and lunatics. In the United States, the parens patriae function belongs with the states, not the federal government. There is no federal probate law. At least in theory, two reasonable but contending people will honor each other and attempt to resolve the problem at hand. In actual practice, often one or the other, or both, will act in dishonor. If both are acting in honor, the court has nothing to decide, for the parties will work it out together. If one of the parties is in dishonor, then the court must look with favor toward the person who is in honor. If both parties are acting in dishonor, the doctrine of parens patriae becomes effective. Meaning, they can rule however the damn well they want to. Now, technically, is this usually the case? Yes. Will the court admit it? No. because they won't ever admit that the state's wrong or that this attorney's wrong, unless you can really slap them in the face with something blatantly obvious, like, I never got served. Or something blatantly obvious, like, well, he didn't answer the plea and abatement. Those things, that's different. If you're thinking about it from a standpoint that the state is in dishonor because they're trying to hold a man who's one of the people of whatever state to the standards and the statutes, acts, ordinance, and codes of that state under public policy, administering his estate as if he were an abandoned infant, that's not just an automatic. They're never going to give up what they're doing in the system. But if you do a counterclaim or countersuit and you demand that they prove their jurisdiction, well, now they don't have any choice but to answer it. And a motion to dismiss for lack of jurisdiction or a counterclaim coming over the top of them, which is the way you should do it, in a court of record saying, hey, I'm in a higher law here. Then if they continue to dishonor it, you have all kinds of other remedy. We'll get into the rest of the remedy, what that would be, when we get into the rest of these documents that I have for the motions and the habeas corpus and so on and so forth. I'll tell you what your 1, 2, 3, 4, 5, 6, 7, 8, 9 step process is. Next one, which are you, people or citizen? People, the preamble does not specifically define the word people. Nevertheless, the definition becomes apparent in the context of the other words in prior history. History. Before the United States existed, there was no legal government. A group of representatives acting, quote, in the name and by the authority of the good people of these colonies, close quote, declared the independence of the colonies from the British Crown and the state of Great Britain. From the beginning, in the 1776 Declaration of Independence, the people were acknowledged as the source of authority, i.e. the sovereignty, which authorized the Declaration of Independence. Next came the 1778 Articles of Confederation. The states that existed by the authority of the people created those articles while in Congress assembled. That didn't work as well as expected. I would say that it probably would have worked better had there not been a lot of influences trying to make it turn into something else, like Washington and Hamilton wanting to create their overlay of a federal government and Hamilton's persistence to demand a central bank. In 1787, the people themselves came forth to ordain and establish this Constitution for the United States of America. See the preamble. On September 17th, 1787, the states held a convention and all those present unanimously joined in. So in 1787, unanimous concurrence was achieved and the Constitution was born, later to be ratified. So the preamble of said, we the people of the United States, in order to form a more perfect union, establish justice, and ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. Okay, structure. Trustor. We the people. The United States of America is a trust. Anybody that got that wrong when they did their questionnaire to join the Vocation of Science and Freedom Gilded Server, I'm not going to hold it against you because a lot of people don't understand this. But when I ask the question, what is the United States of America? I think I gave her either 4 or 5 different multi-choice answers. The proper answer is it's a trust. Okay, it's a trust between the states, because the states were established prior to this thing being established. Because you had the Articles of Confederation, all the states then created their own constitutions, so they were their own nations, and then this thing came along later, and they all got in to a trust to it. What's the venue? The venue is of the United States. Purpose: in order to form a more perfect union, establish justice, yada yada. Beneficiary: to ourselves and our posterity. What's posterity? A post-heir, one that comes after the heirs. Enabling action: do ordain. So what does ordain mean? It means to declare the law. Enabling action 2, and establish. What does establish mean? It means to write it down on a piece of paper. That's all it means. Bring into existence. And then what? What is it? This Constitution. Articles of Incorporation for Trust. Trustee for the United States of America. So the United States of America is the trustee, the ones that have to do our bidding. And there's one part in here that he doesn't bring in, but we're the executors of this whole thing. And if you don't understand how we maintained our position as executors over everything, go read the 9th and 10th article of the Bill of Rights. That will explain everything, because it says in there that anything not delegated is retained And guess who it's retained by? Us, or the states, respectively. So, the analysis of the preamble. The preamble defines the context in which the remainder of the Constitution must be interpreted. Most of it is self-explanatory. Here's an explanation that points to popular sovereignty. After the Declaration of Independence, but before the ordainment and establishment of the Constitution, the people of the United States pretty much handled their own affairs using the common law. They were not subject to any higher authority other than the authority of the common law as administered by the people themselves, self-governance. Although the states did exist, they only existed by the authority of the people. Every man was a king and every woman a queen, and none had any subjects, with the exception of those that owned slaves, I suppose. Upon declaring out independence, we all became sovereigns and members of the peerage, nobility. And this is clear when you can read this particular Lansing versus Smith. The people of the state, as successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Through the medium of their legislature, they may exercise all the powers which previous to the Revolution could only have been exercised either by the king alone or by him in conjunction with his parliament, subject only to those restrictions which have been imposed by the Constitution of this state or of the United States. And that's not the U.S. incorporated, by the way. Obviously, that didn't come until after the Civil War. So, and that's Lansing versus Smith, and here's the decision, and so on and so forth. The enabling actions in the preamble are significant because there is simply nothing in the use of those words to imply that the people relinquished any of their own power and authority. Power is always vested. You can vest power to someone, but guess what? The power itself is still retained in the one that vested the power. If you vest power, it does not mean you give it up permanently. It just means you're letting somebody borrow it for a while. Hence the word vest, to put on a vest and take it off. The people declared the law, ordain, without taking away from themselves the authority to declare law again in the future. Makes perfect sense. In fact, even in the Declaration of Independence, it clearly laid out that we can, if necessary, undo every single bit of government and start over. We can do whatever we want to. But that didn't sit too well with the Khazarian mob bankers that wanted to take over everything, particularly those sitting in the city of London, but I digress. The people established the Constitution without taking away from themselves the authority to establish anything else in the future. In other words, the people gave birth to the Constitution without giving up any of their own power and authority. As I say, vestment of power. What was before continues to be so today. From the context of the preamble, one may conclude that the law of the United States do not apply to people. The people, as ordainer and establisher of the country, are sovereigns of the country. May not be involuntarily subjected to the laws of the United States. Absolutely true. And again, here he brings it up. Because the 10th Amendment, that should actually say the 10th article of the Bill of Rights. You shouldn't refer to the first 10 as amendments. You should refer to the first 10 as articles of the Bill of Rights. That's the proper way to say it. The powers not delegated to the United States by the Constitution or prohibited to it, nor prohibited to the states, are reserved to the states respectively, or to the people. The government has no authority and cannot assume any authority over the people. Government powers may not reach beyond that which is constitutionally granted. In order for the government to subject people, us, to its laws, it is necessary for the people, us, to relinquish their sovereignty, or, as I said before, enter into a contract, or not rebut a presumption. Sovereignty is a natural right which cannot lawfully be relinquished involuntarily, and there's plenty of case law on that too. Any removal of sovereignty must be accomplished voluntarily by the subject himself. That's consent. All just powers of the government are derived from the consent of the governed. Nothing else. I won't get into definition of history of citizen. This is something that we've covered a lot of different places, in a lot of different classes. So skip that. Nor the relationship between these three. We know what they are, so I'll skip that. This is interesting, however. The difference between what the different articles in the Bill of Rights apply to either a citizen of the United States or ones that are not available to the citizens of the United States, meaning the 14th Amendment slaves. So if you're one of the people of the United States, then all 10 amendments, first 10 articles of the Bill of Rights are available to you. You have natural rights. If you are a citizen of the United States, then you have civil rights, properly called civil privileges. See Senate document, page 108 to page 117, 1006, 1007, footnote 37 for details summarized here. And that would be an interesting thing if anybody wants to go see if they can't find that somewhere, sometime, and then put it into the server, because that's probably something everybody should take a look at if we could track that down. So amendments available to U.S. citizens. First, second, fourth, fifth, sixth, eighth, more or less. They're pretty much getting rid of this one. So amendments not available to U.S. citizens, quartering troops in homes, not really any cases about it. Grand jury indictment, trial by jury, bail, excessive bail. Senate documents, analysis and interpretation document, and legal effect of your answer. An addition of the document and subsequent revisions is given free to all elected and past senators, congressmen, and vice presidents, delegates, and resident commissioners upon timely request to the government printing office. This document, Constitution of the United States of America, analysis interpretation, this, I believe, is in the Vocational Science of Freedom free online law library. It's a very long document, and it has a lot of hyperlinks in it. So just warning you, when you first open the document, it will take a long time to open. Do not think that the government is trying to hack your computer or something. The thing's just so bloody big that it takes a long time to open. But anyway, there's a hyperlink right there if you want. Like I said, I'm pretty sure it's in the library. So, sovereignty of the people. Here's some case law, which we're well aware of. Some aspects of the California Government Code, which is interesting. Anybody from California, you guys should definitely write these down and use these. This was actually the same verbiage that I found in the Washington Open Records Act, where it talks about down here, I think it's this one. Yeah, this one right here. From this point on, this is pretty much verbatim of the exact same thing that I found in Washington. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created. That is verbatim of the same thing that I found in the Washington statute. So anyway, basically the government code, the California Government Code is stating openly, flat out, that the people are sovereign and the government's under them. Right? And then the definition of sovereignty, definition of state, some stuff about citizens, how you can see that they're not the same as people. So, and then constitutional preambles, which obviously state a lot of the same thing that we're talking about sovereignty, and some more fun case law, which I always put in the law of the case. Actually, quite a bit of it, which I think I kind of expanded on that too. I don't think that all came from Bill. Okay, and then republic versus democracy. This I won't get into either, but obviously the problem is that we live in a republic, not a democracy. But you guys can read that later, so I'll skip over that for now. Okay, the essence of the common law. This is a back and forth thing between Bill and somebody else that was kind of this interesting debate, which I won't read because it's not really necessary to go all the way through this. But it's something kind of fun. If anybody else has an argument against the fact that we're sovereign, you can look at that debate and kind of go back and forth and get it. Okay. Now we're getting into court stuff. So what is a court? Whatnot. This article is about the substantive definition of a court. For form, legal, and dictionary definitions, see court of record. Most attorneys will tell you that a court is a forum where litigants may take problems for resolution. Others will tell you that the terms court and judge are interchangeable, and they're not, because attorneys are stupid. Then there are the various dictionary definitions, but here is the real substance of a court. A court is a stage upon which the sovereign conducts his show as to satisfy the rest of the world that his decision is a good one. Or another way to put that, to prove to the rest of the world that he's right. The modern concept of a court is based on the ancient English traditions. To best understand it, imagine how things were in the 12th century. The king was the sovereign, on his throne, by divine right. He was the source of all law. So went the theory. But the king was as vulnerable to death as anyone else. So consider this scenario. And this is something to understand about going back to attitude and about having the right attitude. So consider this scenario. The king is sitting on his throne, gazing out the window, surveilling his kingdom. He notices one of the knaves stealing oranges from his favorite orange tree. No problem. Guards are summoned and instructed to incarcerate the knave for a month in the castle dungeon. There you have all the elements of basic court procedure: jurisdiction, evidence, accusation, judgment, punishment. The king had the jurisdiction. He had personally seen the violation of his rules, the evidence. He then rendered and executed the judgment. Theoretically, that's all that's needed. As a practical matter, there's more to the story. In this case, the criminal's brother happens to be the king's chef, cook. The cook takes a day off to visit the dungeon. The prisoner complains about the injustice of it all, that he meant no harm, they didn't do it, and the king was totally unfair. Mr. Cook, enraged by his brother's story, promises to help. That evening, the king dies from a slight overdose of arsenic. That's how the nobility solved problems in those days. The arsenic factor is what led to our modern court system. The royalty of that period realized that they were vulnerable. So they devised a trial system which would encourage others to not take it out on the king. This resulted in a new scenario. And I dare say that's probably not the reason. I mean, it's part and parcel probably why it got expanded. But when you go back to very far back in the Celtic Druidic system and in the Viking system, it was more of a community thing of why courts got established. Anyway, you can just look into the Court of 100, which will explain what I'm getting at. So the new scenario. The king is sitting on his throne, gazing out the window, surveilling his kingdom. He notices that one of the knaves is stealing oranges from his favorite orange tree. No problem. He summons the guards and instructs them to bring the knave before the court. Papers are drawn up, and a formal accusation is published for the world to see. A future date is set, and the knave is given an opportunity to round up defense evidence and witnesses, as well as a king-trained, tested, and licensed defense attorney. On the appointed day, the king's representative publicly announces the accusations, the defendant publicly states his innocence, and the reasons thereof. Great argument is heard from both sides, and the king renders the judgment. 30 dungeon days. Attending the trial are the various court officers, judge, counselors, marshals, so on and so forth, and the prisoner's brother, the king's chef. On visiting day, same thing happens, goes down, he complains, but his brother says this time, "Sorry, I was at the trial. I saw the evidence. I saw that you had an opportunity to defend, and I saw that the judgment was according to law. Even if the judgment was an error, the procedure was fair. There's nothing I can do for you." So the king's show was a success. Because of public judicial procedure, he is guaranteed a long, arsenic-free life, even though there was no difference in the final outcome. So, when people get too yippity about just going out and hanging people, yeah, they're talking about the king's justice. Our job as sovereigns is to put on the best show we can. And everything from telling people that you are a king, as in getting your dock set done, which I took that out of no one has an excuse about that. Okay, it took me 25 years to put a dock set together that's absolutely impossible to be cracked. I've taken that potential problem of putting on a good show and taken away your excuse for it. The status thing is not a problem. The putting on the rest of the show to the rest of the world that these people don't have jurisdiction and that we're coming for them, that's everybody's responsibility to do themselves, because your situations are going to be different. Your jurisdictions are going to be different, meaning the different states. And you have to learn how to put on a good show. There is no substitute, really. I mean, if you did find someone who could put on a better show, then it's certainly not going to be an attorney. I'll tell you that. There might be some other, well, in fact, I know there are some other people out there like me, but most of them will not take on someone's entire case unless it's like their brother or something. Unless they have a bunch of group of people that are all doing it together, like, say, when the Bundys got together and did their thing. That's different, because then everybody's helping everybody and everybody's kind of in the same boat together, sort of deal. To continue, modern courts. Modern courts procedure still adheres to the traditions of the past. You can see this in the various rules, statutes, and canons. For example, in Canon 2 of the Code of Judicial Conduct, it is well understood that, quote, "a judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary," close quote. There is no specific requirement that he actually have integrity and impartiality beyond that minimum required by law, only that the judge should act in a manner that promotes that image. Maintaining image while protecting sovereign interests is probably the most important function of a court. The actual effectiveness of a government court in meting out justice has been questioned. Yeah, I would say so. It's because it's not their courts, and like I said, I will be receiving, in not too distant future, the court cases that prove that once these private for-profit courts have a different purse than the state, then they are their own private corporations, and not only do they not have any jurisdiction, they can absolutely be sued. And of course, as we've already found out, that you can take them through binding arbitration and get an arbitration award against them. So either way, they have no immunity. Spend a day in any traffic court and you'll get the full flavor of how courts protect sovereign interest as they put a show of procedural propriety. Right. Nothing but private for-profit courts running people through the meat grinder to get as much money as they possibly can by only putting on a show, but it has absolutely no authority. So it literally is a bunch of jesters just up there dancing around like morons, and a black robe priest of out collecting the money. That's it. That's all it is. But that's their system. Now let's get into our system and start taking a look at what's going on here. So we've got the study guide. Before I get into court procedure, let's scroll down here. So the 5 jurisdictions of Anglo-American law, and then we'll get into the difference between common law and statutory law. So let's open up handout 2.2, which is chapter 7 of my grand jury manual, the 5 jurisdictions of law, and let's open up 2.3. So there's that, and 2.3 is this. So when you're dealing with courts, there are different jurisdictions of courts, right? So the 5 jurisdictions of Anglo-American law are common law, equity, maritime amity, Roman civil law, also called municipal law. These two are kind of mixed in with each other, sort of. Ecclesiastical, military. I know I have 6 here, but technically it's kind of 5. And then one jurisdiction to infest the rest, which is lex mercatoria, which is the law of merchant. Now this has nothing to do with our Anglo-American law. This has to do with this is basically Luciferian, if you really want to get down to it. It's been perpetuated by the Khazarian mob and out of the city of London, and it's a system that turns every single human into a human resource and a tradable commodity. Let's put it that way. And there's the Wikipedia, you can look it up for lex mercatoria, what it is. So those are the 5 jurisdictions of Anglo-American law. I'm not going to cover them too much, but I will cover this, which is the difference in the various different laws directly out of the Snell Elementary Treatise of the Common Law, which has been given as one of the important books. And this is from the introduction, page 23 and 25, and then I'll go over the chapter 7 of the grand jury manual. Not the whole entire thing, because it's 28 pages, but let me get down here to all right, there we go. We'll start there, and then I'll go through the definition of common law and court of record, and then equity and so forth after that. So I'll start kind of halfway in between, or halfway in the middle of the grand jury manual. And I won't, like I said, I won't even read all the stuff regarding common law because it's fairly lengthy, and it's been covered ad nauseum in the totality of law class. I totally covered it, like the whole entire thing. So actually, truth be told, I think I'll just read out of this one, and I think you guys can take a look at the grand jury manual yourself later. I'll skip that because it is a little bit lengthy. We'll just cover the laws real quick, and then we'll get into process as best we can. How to write a suit, do motions,